at the meeting then, Chris. It looks nice.
Thank you.
Recording in progress.
I'll sign it later.
In
don't have to.
in accordance with provision, Mass General Law, Chapter 30A, Section 20, notice is hereby given that the Zoning Board of Appeals is meeting tonight, Wednesday, June 18th, 2025, at 7 p.m. in the Town Hall Room, Meeting Room 124. Members of the public are welcome to attend this in person at 1 Liberty Lane, Norfolk, Mass., or by the remote Zoom connection provided. Please note that the in-person meeting will not be suspended or terminated if technological problems interrupt the remote connections. So thank you. There are links that are provided on the website.
I'll make a motion that we open the meeting for tonight.
Okay.
And I'll second that motion.
All in favor to open the meeting?
Aye, Joe Sebastiano.
Tim Martin, aye.
Josephine Kordahi, aye.
Chris Metcalf, aye.
David Axberg, aye. Do we have to do name calls
Who's remote?
all night?
Nobody's remote.
Nobody's remote. Okay, good. All right, first one on the docket for 7-1.
Yeah, 701. All right, notice hereby given in accordance with Chapter 48 of the Massachusetts General Laws and any and all amendments thereto that a public hearing will be held by the Zoning Board of Appeals in Room 124 at the Norfolk Municipal Building on June 18th, 2025 for the following application. Patrick Kerrigan at 7:01 p.m. for the appeal of the Building Commissioner Zoning Officer's decision in accordance with Massachusetts General Law, Chapter 48, Section 8 and Section 15. And the Norfolk zoning bylaw, Section 310, Article 7. The applicant is appealing the March 4, 2025 decision of the Norfolk zoning officer, enforcement officer with respect to the zoning enforcement requests that were made by the applicant on November 26, 2024 and December 19, 2024. The property is located 14 Stop River Road, reference assessors map 23, block 76, lot 76 in the R3 zoning district.
All right, at this time, I'm going to recuse myself because I do abut the property in question. You're up.
Okay. Mr. Kerrigan,
Yes.
please join us.
All right, thank you.
You're welcome to sit over there or take a microphone up there, however you're most comfortable.
Patrick, you can sit here if you want.
Okay.
And the microphone will reach just fine. Okay.
And just identify yourself and your address for the record, please, sir.
Hi, good evening. I'm Patrick Kerrigan. I live at 14 Stop River Road in Norfolk. And thank you very much for your time. The November 2024, December 2024 zoning enforcement requests and the April 2025 appeal, in my view, all speak for themselves, and I don't have anything further to add. I'm happy to take any questions. Otherwise, I very much appreciate your consideration.
So just to help us out a little bit, my recollection of the appeals before was generally that there were a lot of concerns, but primarily it was primarily to do with how the construction site was being handled. Is that correct?
I don't think it's possible to summarize. So the November 2024 zoning enforcement request is like over 20 pages, single-spaced. I couldn't possibly summarize it.
Relative to what was going on the ground, did you want to speak towards that at all, or just?
It's pretty well covered in the zoning enforcement request. If you guys have any questions, follow-up questions.
I had one question. I think you had another appeal on the open meeting law. Was that?
That's correct.
I think we'll do these one at a time.
Okay.
So let's do this one first.
Okay. So I'll open it up to the board. Any questions for Mr. Kerrigan on his appeal?
I don't have one at the moment.
What specifically is being, I thought there was an appeal of a building permit for this
I think it was the appeal of the actual
Could you remind me of what
The approval.
specifically, okay. What was specifically appealed? The zoning enforcement requests are not necessarily being appealed.
I guess my question would be just
I'm just wondering, what were the triggering actions? Was there a building permit issued that you appealed? Was it, were you appealing, it wouldn't have been our decision for the entire development because that
I
wouldn't have
believe
been
that was part of it.
but the appeal for the entire
No,
development would have been within 90 days of the original
Right.
decision, so that's not timely. So it must have, what you filed an appeal of in November and December, what were you appealing?
I wasn't appealing anything in November.
Okay.
So those were zoning enforcement requests.
Okay, so those are simply zoning enforcement. Okay, so
Correct.
we don't have an appeal in front of us.
You do.
Per se.
The appeal was filed in April.
The appeal to the enforcement action.
So
Are you
were-
appealing the declination of the building commissioner to, I'm trying to remember, because we heard the building permit, we
Right.
found in favor of the building commissioner,
And then he filed an
that's-
enforcement action, I believe, with the building inspector, or building department.
so a subsequent request for
And
enforcement
he's
following that
appealing
decision.
that filing.
Okay, dig it, sorry. Just catching up on what the event, what the specific event we are, what's in play.
Thank you very much.
Is there anything in particular on that, on your appeal of that decision that you're appealing? Is it, or just the entire decision? Are the things more paramount than others?
No, I would refer the board to my November 2024 and December 2024 zoning enforcement request, and then my April 2025 appeal of the March decision.
Okay. And you filed the appeal. Is there any, and what relief were you asking for?
I would refer you to the zoning
Okay.
enforcement request.
That's fine. Is there anybody in the audience that has any questions? Is there anybody on Zoom that has any questions?
I would just ask, what do you want done? Do you want overall this stopped?
Well, I asked,
Stopped?
why don't you just identify yourself?
I'm in a butter, I'm Max Holt, and ultimately, like, my family lives in this subdivision. I live right next to some of the construction. A 1 and a 3-year-old. They're doing well
Okay.
right now. And ultimately, like, I want the construction to continue so that we don't live in a construction site for the rest of our lives and not paused, as well as, like, hey, this only has 1 coat of blacktop on it, which makes sense because there's construction vehicles driving on this road. When the construction's done, it needs another coat of blacktop. So when that gets held back through time, that's where my concern's at.
Okay, and I think I asked Mr. Kerrigan that question, what relief he's looking for, and he's referred us to his filing. So we'll review that again.
I know.
And let me ask you, sir, if you want to, are there any specific, it sounds like you're in favor of the construction going on, are there any issues that you've seen out there that would support Mr. Kerrigan's complaint?
So, but his complaint is before we moved in, I will say that, but
Okay.
no, so like, since we've moved in, it's, yeah.
Okay, thank you. Is there anybody else that has any questions or concerns on this?
Could I ask one question?
Certainly, go right ahead.
I remember when you came in, I remember your filing. We read, just so you know, that it didn't just like come in, floated, and like, disappear. And I remember a lot of your complaints stemmed around blasting, water infiltration, and things like that, correct? I also recall that a lot of the work was being done during a particularly rainy season. Are you currently experiencing impacts on your property at this point in time or within the last, 3 to 6 months during what ostensibly would have been winter melt, had we had more winter melt, but it was wet, we were out of a drought, but has it been ongoing or has it
Yes.
been remedied? Okay.
Yeah, so our basement has water now, so that's one problem. Another problem is, and I have discussed the vibration issue and the blasting issue with the board now for basically what feels like years probably. So now the problems have evolved and escalated to the point where if there's equipment operating at the top of the hill, it's now causing our baseboards to vibrate. So something has further deteriorated. So now every time there's a piece of equipment at the top of the hill, our baseboards are vibrating. There's issues.
Thank you.
Is there anybody else who would like to add anything, have any questions?
Yeah, Mr. Chairman, Christopher Agostino, counsel for Lakeland Hills LLC, which is the developer of the project site in question. Thank you very much. Again, sorry, Christopher Agostino, counsel for Lakeland Hills LLC. I wanted to point out procedurally, just so that we're all on the same page here, I reviewed the application for an appeal under Section 8 that is dated April 2nd, 2025. And the voluminous materials that were submitted with it dating back months. And then I just heard the presentation that the applicant made to the board, which wasn't very specific, and I really couldn't discern exactly what the relief requested was. So given that, I wanted to make sure that procedurally we're all on the same page here. I don't believe there's any request that is properly before the board right now. The original request for enforcement was from back in 2024. The law requires that if the building inspector does not act within 35 days, then any appeal of the building inspector's failure to act be brought within 30 days of that failure to act within 35 days. So the prior enforcement requests jurisdictionally are invalid. They're null. There's nothing to appeal. And it's a jurisdictional prerequisite that the procedures be followed for an appeal, and that wasn't met here. As to the November and any prior decisions, there was a decision of the building inspector that was issued in early March, and this most recent letter was submitted on April 2nd, and it's stamped by the zoning board. The procedure requires that any appeal of the zoning enforcement officer's decision be filed with the town clerk's office. I don't see that this was filed with the town clerk's office, and again, that's a jurisdictional prerequisite for this board to actually hear any appeal. I can supply case law and cite to Section 15, which is pretty specific on the procedures. But jurisdictionally, there's nothing before this board. That's not to say that we're not here to hear any real concerns and answer any real problems. I believe I appeared before this board last year in response to a similarly inadequate appeal that was brought before the board about concerns ranging from blasting to stormwater to wetlands protection. And at the time, we offered, as the applicant, if there are real concerns that are identified, we are willing to sit down and talk through them and see what we can do. The response we got was similar to what I heard presented to the board this evening, which was kind of misdirection, obfuscation, vague threats, and I'm not really sure what the request is before this board, and I'm not really sure what the request is to the applicant. We stand before you willing to answer real questions and solve real concerns, but we can't do anything if proper procedure isn't followed. And I think a lot of this documentation requests information regarding procedure, and where the application itself doesn't follow procedure, it kind of leaves us in a difficult position in that we're really not sure what we're being asked to answer, where we stand here willing to have a conversation and see if we can solve problems. So I don't believe the board has a proper jurisdictionally submitted application before it, and I would just leave it at that. But otherwise, on behalf of the applicant, I'm willing to answer any other questions the board or the petitioner might have.
Thank you. I'll turn to town council. I don't know if you can give us some advice on that relative to, I don't want to have a hearing going on if procedurally we shouldn't be having it.
Well, on the front page of the copy of Mr. Kerrigan's appeal that I have in front of me, it says that there's a town clerk stamp on it for April 2nd, and it was signed by the town clerk. So I don't know, I wasn't there when these papers were filed, but town clerk certified that it was filed on April 2nd.
Okay.
Can I ask the question to council?
Sure.
Where'd you get the 30-day building inspector doesn't respond, and then if you don't appeal that in timeline, because
30 days on a building commissioner, isn't that in the building code?
No, because
Or on the
my
building inspector?
Because, I know of case law, particularly like the Connors versus Nino case that says that the 14-day period to respond to an enforcement request is discretionary. That doesn't make much sense to me, but that's what the SJC said. So, and I'm sure you have it somewhere, but I'd just like to know where that came from.
Yeah, so it's 48 Section 13. Any appeal, application, or petition filed with said zoning administrator as to which no decision is issued within 35 days from the date the filing shall be deemed denied and shall be subject to appeal as provided in Section 8. And if you refer to 8 and 15, it says within 30 days of the date it's deemed denied.
Okay.
And there is case law that follows, and it is jurisdictional prerequisite. But just a quick follow-up.
I agree.
Yeah, and just like Chris was saying before, this is why we...
Oh, just identify yourself. I don't want to...
This is Owen Kelly from, this is...
It won't project, so it feels
It's just
awkward,
recording.
but
No,
it's
it's
for our tens of viewers on the TV.
This is Owen Kelly from Lakeland Hills. We're here, we weren't trying to file to say, hey, this isn't a hearing that should be had. Just like last time, our goal is to see if there are issues, we want to be solving them. I'm there many times a week. The applicant has my direct contact information. I have not received any direct contact from him since the last time we were here with the board. That's not to say that he has every right to go about pursuit of any public information and use any route to make sure that him and his family are protected. So he doesn't have to go through me, but I'm hopeful today that we can identify real issues and
Okay.
solve real problems. Yep.
Thank you. So I'll go back to town council on whether or not we should continue to have this hearing tonight.
I'm reading
Okay.
Chapter 48, Section 13.
I'm
It's
gonna
not
hold off
long,
one
but I
minute.
just want to read it.
I don't know that
just
we're
gonna hold
making
off one-
any decisions tonight.
No, I just
either.
want to hold off before, I don't want to get ahead of myself. Procedurally, we shouldn't be doing it. I'm going to hold off a minute, Mr. Kerrigan. I want to get an opinion from council.
That's fine. But it has to do with what he's looking at. I don't...
We're gonna take a pause, though, for
I'll
our
let him look at it
attorneys, yeah.
first, but thank you.
Mr. Chairman,
We're still going to pause.
I just wanted to say, the only question I have is, I don't have a copy that has a town clerk stamp. If it exists, that's fine. I think that's something, the only stamp I have is the zoning board. But if it was filed in the town clerk's office, then that solves that.
I can see Carol Green's John Hancock right there.
Down below, you can see a
You
timestamp.
go to the top of the page, it has a stamp on it.
Yeah, oh, and we do have the upside down timestamp.
Yeah, and there's one at the top of that page.
Oh, March 33, the timestamp was misbehaving that day. Hate when that.
Go to the top.
I know, but I hate when the timestamp does that and it decides there's many more days in a month.
There you go.
Yeah,
Right there.
yes, that's corrected. They get wild sometimes.
Yeah, he was previously filed, so we heard of it. But thank you.
Okay.
Let's go to see it.
All right, so we're in a strange timeline position here. I think it's correct that 40A, Section 13 says that if you don't get a decision, then you revert back to 48, Section 8, and then you have to appeal the non-decision within 30 days of the deadline of when you should have gotten a decision. And that didn't happen here. However, the building commissioner issued a decision, and that decision was dated, sorry, I'm just, March 4th, and this appeal was filed on April 2nd, which, when you get a decision from the building commissioner, you have 30 days to appeal it. So
It's in play.
this is kind of a strange situation, but it's not Mr. Kerrigan's fault
It took
that the
that long.
decision came late. and he ended up timely appealing the decision he received.
Okay, so you think we're on good standing to continue on with the hearing?
I am uncertain how this answer would be questioned if challenged, but I think, given the fact that a decision was issued and timely appealed.
Well, since we're here,
Yeah.
everyone's here, and I'm not hearing anything to indicate that we shouldn't go forward, I'm going to keep the hearing open. So, and Mr. Kerrigan, back to you, sir.
Yeah, just really quickly, two things. The first is, sir, there's no obfuscation going on.
Mr. Kerrigan, just direct your questions to
Well,
the board.
I have to, I mean, I'm
We
sorry.
don't do tit for tat
If
and
you
back
want to do that
and
in the
forth, just
hallway, you're
us.
welcome
Yeah,
to.
Just us,
Okay.
just the chair.
Yeah.
Will do. So I'm going to respond to something that was said, and I'll direct it through the chair.
Please.
So,
Did the chair say it, or a board member? Just trying to keep it not personal.
it's not personal, but I think it's important to contextualize what's going on here, because if one were to listen to that presentation and then the follow-on, it could distort the reality of this situation. And the reality of this situation is that I have undertaken at great personal cost to myself as far as time, effort, and energy, and time away from my family and sacrifice, sought to, in effect, monitor a construction project behind our house that has had tremendous negative impact on us from the second they broke ground, okay? And what I'm talking about, as you all know, massive rock crushing machines right on the hill behind our house, spitting out all types of dust, which I now have a son who was diagnosed with asthma in April of 2023. So this is not something, okay, these are very serious issues, and this is not something where, there was like, a little scrape on the pavement or something like that, and it's something we could have worked out. I mean, these are big ticket items that I have made good faith efforts to try to resolve in April of 2022, and it didn't happen. So this is why we're here.
I understand you filed an
Yeah.
appeal.
No, but I'm talking about a conversation that I had with the developer when he arrived at my house in April of 2022, and I mean, stuff was already happening up there, and I said, look, don't harm me, because if you do, I'm going to protect my family. And now we're here. So
Yeah, I don't
have
no,
any-
no one's here really saying that you haven't reached out and think, I'm just trying to get to the substance of the matter.
Can I ask one question pertinent on the civil side, which is not necessarily outside of our lane, but in construction property damages? I'm pretty sure you've told us previously that you're an attorney. I think you worked for the Obama administration, if I remember you correctly. So I think this will jive with you, that there are civil matters and then there are matters of public policy. Nobody here is necessarily denying or confirming that any injury has occurred, but what I am going to ask is whether or not any claims have been filed against any insurance policy relative to this development. Either the developer's policy, the blast company's policies, has any civil...
And you don't have to answer that.
You don't have to, but I'm curious if any
I don't want to
civil
go too far
remedy
off the
has
beaten
been-
path, but
Yeah, has been sought.
why? Out of curiosity.
Efficacy. What we can do as a board and as with the building commission and the building inspector, based on the rules that we have, the state laws, and the fact that they've generally been found to be operating within the boundaries of their permits, but the fact that you are still experiencing an injury, it's not, again, our lane or our place to say, but I'm just kind of curious because, again, I'm not denying or confirming whether or not you've experienced injury, but whether or not you've sought recourse in addition to with the town, but also on the private side.
Yeah, I mean, I think, as the chair suggested, I think why we're here tonight is because I filed two zoning enforcement
we'll keep it narrow and focused to that word, but I appreciate the comments.
But I think you understand my point, that there's a civil process that is generally designed to handle matters like yours, as opposed to the public process that is being used.
So I'm just going to open it up again. If there are any other questions from board members or anybody else in the audience or anybody on Zoom.
One question. Is there anything we can recap as far as what's been done since they first met and discussed the issues there, meeting the developer and Mr. Kerrigan?
So, Mr.
What did the developer do after hearing any Mr. Kerrigan's complaint? Is there a little short
Let
timeline?
me help you out with that a little bit. Maybe it's the same thing, maybe it's different. If not,
Okay.
we'll find out. So, Mr. Kerrigan, since you filed your appeal 60 days ago now, is there any difference, not to what happened, but on what's going on out there these days, in the last 60 days?
We're still obviously being impacted. I mentioned the thing with the baseboard. I mean, on Monday, I was trying to work from home. It was so loud, about middle of the day, I had to leave my house and go into Boston and work out of my office in Boston.
So the situation is similar to what it was 90 or 120 days ago, or?
Yeah,
I'm just trying to find from the time of filing to today.
I appreciate that, yeah.
And, Owen, you have a question or comment?
Yeah, just the comment that I'm very happy to pursue comments from. There's now all of the homes between Mr. Kerrigan's property and any continuing construction have been completed and are occupied by residents. We have a process that we typically stay connected with the people in our development to make sure that any issues are going on, that they're being heard, and that I have not to date heard any issues similar to what Mr. Kerrigan is driving from them, but we will solicit those homeowners to make sure. I believe that the Max who spoke earlier is one of those. But again, we will seek questions from other people, but there are people living between any active work and Mr. Kerrigan's property now.
Thank you. Is there any other questions? Did I answer your question?
No, that's good.
Okay, thank you. Any other questions from the board? Anybody else in the audience?
I just have a question about what Mr. Kerrigan's problem was with Robert Bullock's response. Which were the items that have not been addressed in his? Has that encouraged you to come back here? It seemed to me that there were a lot of discussion in this letter from Mr. Bullock stating that the developer had taken a lot of actions. Do you disagree that the developer took those actions? Or they're not sufficient?
Well, could you describe what actions were taken? Let's start there.
The actions like moving the crushing site further away from your property, was that done? Is that what your issues are with still? Or is it something else?
Sorry, sir. This is the November 2024 zoning enforcement request is over 20 pages.
But the decision by Mr. Bullock.
Mr. Bullock, is the decision I'm asking is
very specific.
His letter is very, very specific, and it seems that you have an issue with the comments that are in that letter. Are you disputing that the developer took action? And that's what encouraged you to write these 24 pages?
In your opinion, is that letter factually correct?
No, he says that I filed in December of 2024 somewhere in there, which is not factually correct. Sir, are you aware of basically there's two things in that letter as I recall. Okay.
The question I'm having is, there's a section in there that says specifically that the developer moved
doing a reasonable job, that he's moved the rock crusher. The letter goes on to list specific activities that were performed. So the question that he is asking you is if you're refuting whether or not these activities occurred, or if you just found that these activities were insufficiently addressing the situation. A or B?
Right. Well, I think it's going to be C, which is that this letter very much insufficiently responds to my zoning enforcement requests. That's the first thing. The second thing, are you aware of when, one of the...
Let me just ask you the question again, because
I think
it's helpful to the board. We're happy to hear this, but I just want to understand, is that letter, to the extent that it's drafted, accurate? It may be insufficient, it may not tell 1,000 things, but it says what it says. Is what there is accurate? It may not be the accurate total picture.
That a rock crusher was moved? I mean, you'd have to ask, I mean, first of all.
So you don't know. The answer is that you don't know.
Well, I do know that at some point it was moved off of the hill behind my house, but was it still affecting me? Yeah, but was it moved off the hill? It was. But, I mean, this is a 20-some-odd page zoning enforcement request.
Right, but I'm referring to the response that's on appeal here, that this is what we're looking at.
Yeah, well, yeah, because this is what you're looking at, because this is what was given in response to my zoning enforcement
Correct.
request, which I can't control.
I understand
All
that.
I can do is refer to the board to the November 2024 zoning enforcement request and the December 2024 zoning enforcement request. That's all that I can do. And I did my very best, as you would see, sir, in my April appeal, to respond to what was in this letter. But I would ask you, so the other thing in here actually.
But one of the things you need to know, everybody on this board are volunteers. We're not lawyers. So I still want an answer to that, what your issue is with the comments from Mr. Bullock's letter, because you haven't answered it.
Well, sir, I have answered it. I don't have, my issue with the letter is, I appealed this letter because no action was taken on my zoning enforcement request. That's the process. I put in a zoning enforcement request. The zoning enforcement request should have been appropriately responded to. It wasn't. So if it's not appropriately responded to, I can't respond to nothing.
Mr. Kerrigan, your letter doesn't address your original appeal.
I think the issue is that typically when an appeal is filed, I understand that you filed the 26-page request for enforcement, which highlights each individual point, which again, it's attached to, this is Exhibit B, so it's not like the letter didn't come with it. However, typically when somebody appeals a decision, they submit a brief of some variety summarizing what specifically it is that they are appealing, so that we as a board of volunteers and also a court of competent jurisdiction, should this carry forward to a next appealable event, is clear on what it is that was appealed, because it's not enough to say, well, it was the letter. You have to actually be more specific than that and say, this is what I object to in this letter. I find it either A, factually inaccurate, or B, factually insufficient. And again, it's not to say I submitted 26 pages, he did 1.5, so it's not 1 for 1, but it is to say that we have no reason not to trust the building inspector when he tells us that what he has witnessed on site after several site visits repeatedly is the same scene, and where some level of accommodation has been occurring, where the level of dust is being appropriately managed in his determination, which it is his determination that determines whether, you know, there's a part of performance standards where eventually you'll kick over to sprayers and stuff like that, but he's not there. And so unless there is something specific that you find erroneous that the building commissioner did that you want to tell us in this letter, because that's the appealable event, we're unclear even
This would be
still.
the time to
It
tell us.
sounds,
Otherwise,
I know it
let's-
sounds stupid, we understand.
I think I can clarify the issue. All right, so in appeals like this, it's Mr. Kerrigan's burden to present evidence and prove the violations that he believes are occurring. It's just my opinion. It's not sufficient just to refer back to the request for enforcement. And I know these things are long that he's drafted, but I think the board has to go one by one and ask if Mr. Kerrigan has any evidence to support a violation. Because one of the issues I'm seeing with these enforcement requests is, he'll cite a part of the comprehensive permit, and then he'll say, to the extent such requirements were not met or not currently being met, the developer is in violation. It doesn't explain why. And it seems like, from the way it's written, that he's not even sure if there is a violation. It's almost more like a request for Bob to go inspect than, here's a set of facts that demonstrate that this part of the comprehensive permit is being violated. And now that we're at the hearing, it's the law is that it's his burden to come show you evidence that it's true. Just showing you the enforcement request letter is not evidence that these things are happening, especially the way it's written, where it's not even definitive. It's saying to the extent this is happening, I want it enforced. It doesn't say 1, 2, 3, 4, 5, therefore, this is a violation and I want, Bob Bullock to go enforce it.
Are you suggesting that I go through his letter from before or through this letter line by line? Or both?
I think he has 3 requests for enforcement. And you don't need to take a vote on everyone, but if he's alleging dozens of violations, it's his burden to show that each violation is actually occurring.
Can we continue this for the petitioner to have the time to
Oh, yeah, you don't have to
develop such a
decide
record?
tonight.
Yeah.
That's up to the board. If Mr. Kerrigan agrees, that's perfectly fine, but
Okay. Thank you. So that being said, to be fair to Mr. Kerrigan, I'll entertain a motion to continue the hearing. So, and you can anticipate that we'll go through that if you'd like to attend the next hearing, and we'll walk through that line by line. Should give you time to prepare, as opposed to a blanket statement. Yeah. So if somebody wants to make a motion to continue it, entertain that.
Okay, I'll make a motion that we continue the hearing for the appeal of the building commissioner, zoning officer's decision for 14 Stop River Road, Patrick Kerrigan, to July 16 at 7:01 PM.
Is there a second?
Second that.
Okay. Roll call vote.
I, Joe Sebastiano.
Aye, Chris Metcalf.
Aye, Tim Martin.
Josephine Kordahi.
Thank you.
Thanks very much.
Might be good to invite the building commissioner when we schedule this again.
We can always vote, but whether they show up.
Yeah, whether or not he wants to. That's it. We can
Miss-
always invite.
as far as I understand it, Mr. Bullock is retired as of July 11th.
So he's not going to want to go, is the thing.
We'll walk through it. We'll
Okay.
walk through it.
All right.
Line by line, one by line.
Yeah, we'll do, yep.
Yep.
But, yeah. All right.
So there's a oddity in the agenda that also mentions
The open meeting.
open meeting law complaint. So I think what we should do is open a meeting to discuss that, so we can discuss it briefly, and it shouldn't take more than 5 minutes.
Right.
We're under a 14-day deadline to send a written response back.
Okay.
Right. There's no notice of hearing for that. We just open up a discussion?
Yeah.
Okay.
Should we do that after the next?
Do
So,
it tonight.
Well, Mr. Kerrigan's here, it says
Yeah, it's fine.
open meeting law complaint, so.
Now's a good time to.
now's a good time.
Yeah.
Right.
Okay.
All right, so.
Do I hear a motion to
I'm going
open
to
the
try,
meeting?
see if I do it
for that?
correctly. I make a motion that we open a discussion of the open meeting law complaint from Mr. Patrick Kerrigan.
And I'll second that motion.
All in favor, say aye.
I, Joe Sebastiano.
Chris Metcalf, aye.
David Axberg, aye.
Tim Martin, aye.
Josephine Kordahi, aye.
So the meeting is now open for the open meeting law. And there
Can we get a quick summary from council on this one?
Yep,
Yeah, so.
that's what I was going to ask.
Mr. Kerrigan filed an open meeting law complaint relative to January 15th, March 19th, and May 21st, 2025, series of executive sessions before this board where the board discussed the 115 Park Street matter. He received a response that, and I'm summarizing, that says that the litigation is ongoing. The executive session is private, and from what I understand, those minutes were not produced. So we get the open meeting law complaint, and what I need from the board is authority to draft a written response to Mr. Kerrigan. That's due 2 weeks from June 16th. so you won't meet before the deadline. And from reading the complaint and, understanding the executive sessions, we don't think there was an open meeting law complaint at all. And really, this was a request for documents, mainly the minutes from those executive session meetings. So the open meeting law complaint is not the proper avenue to file an appeal if you're unhappy with a response to a document request. And that would be that's a very high level summary of what our response would be. So what I'd like is a motion to authorize my office to draft the response, and then for the chair himself to approve the response before it goes out, so we don't have to convene another meeting or executive session before the deadline.
Does Dave have to recuse himself from
No, because this does not pertain to
that development,
that
right?
development.
Dig it.
It has to do with 115 Park Street.
But yeah, it's not a
And I'm
neighbor
not in a
problem.
butter of him.
Yeah, dig it.
All right,
make a
well,
motion, Joe?
Yeah, I'll make the motion that we allow council to draft up a response from Mr. Kerrigan related to this open meeting law complaint filed, and allow, then Dave would review it and approve the response.
And I'll second that motion.
Do I hear all in favor?
Aye. Do we have to name ourselves? No, the aye. Joe Sebastiano. No.
Aye.
Aye.
All in favor? Thank you.
Very good.
Mr. Chairman, may
Yes,
I
sir.
address a procedural point to town council?
Absolutely.
Under Section 15, there are time standards regarding the issuance of a decision to the extent there is an application probably before the board on the appeal of inaction or action. And there is a 100-day deadline for the issuance of a decision that measures from the date of the application. I haven't looked exactly where we are, but if the application was filed April 2nd,
Does this have to do with his?
Not 115 Park.
sorry, it has to do with the Stop River Road.
Yeah, so we can't talk about it because it's closed.
We're
But,
continuing it. Send us a note in writing.
well, if you want to send me an email or call me even, I'm happy to talk to you. It's just we can't do it.
Send it through the chair, please. Thank you.
Okay.
I'll pass it
We
on.
continued this at one time.
Having a discussion about the previous hearing would be an open meeting law violation, which we don't want to do, so.
There isn't any chance to reopen the hearing, is there?
You can ask the chair.
Mr. Chairman,
It goes to him.
Or, sorry, Vice Chair.
I'm not here.
there may be a procedural concern with...
We'd ask you to reopen first and then
Oh,
discuss.
sorry. I would ask the chair to consider reopening the hearing on 14 Stop River Road's application to consider the potential consequences of the date to which the proposed continuance was made, because there is a 100-day time standard under Section 15, which may be implicated if you extend to July 18th. I believe under Section 15, there may be a requirement that the board issue a decision within 100 days of the date of the application. May, June, July, we're getting, I don't have my calendar out, but I think it's right around 100 days.
Council, why don't I get a motion to open the meeting? And then-
I don't think I can move.
No, not from you. Then we can hear more from you.
Okay.
Anybody want to
Yeah.
make a motion?
I'll make a motion that we do reopen the hearing for 14 Stop River Road, the appeal of the decision of the Norfolk zoning enforcement officer. Need a second?
I'll second that.
So typically, when there's a statutory time.
Everybody, just say everybody aye, everybody agree?
I'm making
All those in
assumptions.
favor?
Okay, aye.
Aye.
All right. All right.
Okay,
All right,
and now
we're
back to
reopened.
council on meetings back open again, and talk to us about the time frame and the statute.
Chris Fragastino, counsel for Lakeland Hills LLC. The board just heard the application of the owner of 14 Stop River Road, which is an appeal under Section 15 of Chapter 40A. Section 15 of Chapter 48 provides that any appeal under Section 8 to the permit granting authority shall be taken in accordance with the following standards. Within that section, there is a provision that provides that the decision of the board shall be made within 100 days after the date of the filing of an appeal, application, or petition, except in regard to special permits, which I don't believe this is, as provided, special permits, which again is not applicable. It does say, however, the required time limits for a public hearing and said action may be extended by written agreement between the applicant and the Board of Appeals. So the applicant could agree to extend that time standard just to accommodate the July 18th hearing, which would solve the concern or any procedural concern. I don't know if town council has another take on that particular provision, but I just want to make sure we consider the issue and don't miss anything.
So I don't have another take on it, but on April 28th, Mr. Kerrigan signed a letter to the zoning board requesting an extension of, or asking to continue the matter to June 18th tonight. And then in that letter, he says, in making this request, I agree to waive the requirements of General Law, Chapter 48, Section 15, where the board must hold a hearing on my appeal within 65 days and render a decision within 100 days.
All right, so we've got that in
he
writing.
waived the
Okay, so
Section
we have that in
15
writing.
Okey dokey.
deadline.
Very
Anybody
good.
want a motion to close?
Very good, thank you.
It's not closed, we're going back to continue.
continuing.
Right, so I'm going to repeat my earlier motion that we continue this hearing until July 16th at 7:01 PM for 14 Stop River Road, the appeal of the decision of the Norfolk Zoning Enforcement Officer's decision.
And I'll second that motion.
Mr. Chairman, can I be heard? I apologize. I have another commitment that evening. I would like to be present, if at all possible, on behalf of the applicant. Is there another date in July that might work? And it's totally at the board's option. We can obviously find...
Why don't, can we have to continue to a date certain, or can we just continue to our next hearing?
Either that or we can continue to our August meeting.
When's the next, is there a hearing before that date?
We got
No.
the 16th, and then
Usually once
next one
a
be
month.
mid-August. Yeah, the next one would have been August 20th.
It's a significant order to put together evidence
Right, and
of each of these
the
complaints.
petitioner has also asked,
Petitioner.
has granted us an extension,
Yeah.
and it is a lengthy, that I'd like to have, the developers' council be present, because it is a lengthy request. So, if we
And
want
I
to...
would anticipate we're getting more evidence to
Right.
substantiate point by point each of the 26 pages.
That was just a lot more time.
Yeah, so we'll need more time. You'll need more time to prepare too, to submit that to us and also council and everybody else. Okay.
Right, so we haven't really continued this yet to...
No, because it hasn't been a vote.
So we want to rechange the motion to try to continue to August?
Correct.
All right. All right, I'll make a motion that we continue the hearing for 14 Stop River Road to August 20th at 7:01 PM.
And I'll second that motion. All those in favor?
Aye.
Aye. Aye.
Aye.
Okay, thank you.
Thank you very much. Thank you.
Thank you.
Okay, Park Street. Welcome back.
Yeah, thanks. All right. The 115 Park Street's already open, by the way.
Okay,
Right, so we don't have to do anything special to reopen.
so
Again, it's, we have to identify, all right, go ahead. How are we going to start this?
let's have council give us an update. Where are we at?
If you sit in that chair, the microphone...
Can I stand here?
Yeah,
I think
just use the
Mr.
microphone
Corner
if you do.
can go first and explain why they're here and what they're appealing. You can all chat after.
Okay.
Okay.
I hear one.
Do I understand the hearing is...
It is.
It's already open from
It's
before.
already
This
open.
is just a continuance.
I know this is matters that continued a number of times, and I
Correct.
appreciate the board's indulgence on that. Mr. Chairman, members of the board, my name is Mark Horner. I'm counsel to Timothy Conowitz. Sorry, grab it from... Thanks. Councilor Mr. Conowitz, I'm here regarding an appeal from the building inspector's stop work order with respect to my client's operations at 115 Park Street in Norfolk. This is, I submitted a hopefully helpful short memorandum of my client's position. I hope you found that helpful. I know there's a lot of history on this property, and I'm not sure how much substantively you've been involved in it, so I'll try to keep my presentation short. This, as I believe you're aware, there's a history of litigation regarding between the town and my client, and also the owners of the property, the Zertz Family Trust. There are two matters currently pending before Norfolk Superior Court. Basically, there is no next event in that case. So this, again, this stop work order was issued on October 28th of 2024 by the building commissioner after in light of the pending litigation matters. The stop work order calls upon my client to cease and desist all excavation and trucking activities at 115 Park Street, and states that any use not specifically enumerated in a district herein shall be deemed prohibited. A word or two about the property. It's just under 13 acres. There's a single-family residence on the property, which is in which John Zertz, one of the trustees of the trust, lives. The primary use of the property is agriculture. It's largely devoted to farming of butternut squash and other vegetables. Despite the building commissioner's statement that it's not a permitted use, the primary permitted use is agricultural use, which is permitted use in the R3 district, as it is in all residential districts. Mr. John Zertz has conducted agricultural operations on this property since dating back to his father developed it in 1957. Mr. Conowitz has worked with Mr. Zertz to help him in his farming operations for going on 25 years now, and his use of the property has been consistent with what it is to date. He has an excavating business known as Miles of Excavating, and he stores his trucks and equipment on the property, and he also helps Mr. Zertz in the agricultural operations. And there is some use of his vehicles and excavating equipment in connection with the agricultural operation. Despite the building commissioner's assertion, there's no excavating activity going on there. There's no dirt being removed from the property. There is some screening of loam that's ancillary to both the farming operation as well as as the excavating company. But the only excavating that's actually been done on the property is excavating associated with the construction of a berm along the property line that was constructed at the request of the town, and which has since been removed at the request of the town. As I've stated in my letter, Mr. Conowitz's use of the property is ancillary to the agricultural use. There's a seven-point analysis that's conducted to determine whether it is in fact ancillary, and some of the case law actually talks about excavating, and quite candidly, there are situations where excavating has been deemed the primary use or too extensive. That simply isn't the case here, because as I've noted, the excavating operations relate to minor uses of the property for agricultural purposes. So, as you know, the board has continued this matter for a number of times. My client, and it would ask that the board deny or grant the appeal and permit my client to continue his operations on the premises, subject to the conditions that he operate consistently with this plan, which you may have seen before. You'll be conducting screening operations here, which is some distance from the property line over here, and also parking his equipment and vehicles on this portion of the property, which again, some distance from the property line on the other side. He would also agree to, he's offered to and would agree to a condition about the hours of operation of screening and not to operate on holidays, and has agreed to permit appropriate inspection to determine that he is in fact operating in accordance with these terms. So this is essentially asking the board to act in a manner that will allow Mr. Conowitz to continue to operate on the premises as he has for around the past 25 years. This would be for a relatively short duration, because there is probably no surprise that there is a dispute between my client and the Zertz family. We've actually have an agreement in principle there by which Mr. Conowitz would continue to operate on the premises under a lease for a period of 1 year. There is some provision for extensions, but we would be talking about a finite period of time. This would have the result of basically allowing the operations to continue as they have historically, and would have the ability to hopefully lead to a glide path of ending all the litigation between my client and the town. So again, we would ask that the board grant our appeal and permit my client to operate on the property, subject to both the conditions contained on the map and as well as those stated in my letter. Happy to answer any questions. Mr. Conowitz is available to answer any questions that the board might have. Thank you.
You made a statement in what you just said that there's no soil removed from the property. Is that true? There's no trucks leaving there with soil in them?
That is my understanding.
When we take the loom for the jobs, of course they're leaving the soil.
So there's
But it's a lot smaller amount leaving than what we're using, because where we used to be, we have to redo that whole field.
So let me, I just want to be clear from what he said.
Yep.
He said there was no soil leaving. There is soil leaving. It's what comes in and goes back out after it's been screened.
Yep.
right, but it's not. Correct me if I'm wrong, but we're not digging up soil on the property, which is.
I understand what you're saying now.
Right, yeah, and if I misled you, I apologize. That wasn't my intention, but that, and I use it in that context because those are the issues that the cases talk about.
When the soil leaves, why does it leave by truck?
I've been bringing in compost in the fields, and I've been bringing in loam and mixing it.
Yeah.
Some of it, if the loam's no good, I take it and use it. If it's no good for the planting vegetables, I take it and you can use it for grass.
And where do you need grass?
On my jobs.
That you get paid for?
Yes.
So is the seeding part of the job?
What seeding?
When you reseed after the work is done, it seems to me we had a very difficult time as a town establishing whether or not there was any commercial nexus to the soil leaving the ground. So I think we just established the commercial nexus.
So the screening area is not used just for soils from that site?
No.
It's used from materials that you bring in?
Correct.
And then
goes off-site for other jobs.
And then it goes off-site
Where
for
the
seeding and
is
other jobs?
Part of the contract.
Okay.
That gets paid for.
So could you clarify, was this screening always going on for the last 20 years, or is this something new?
Since 2000, I've screened.
Because
I can just show you real quick.
well, we visited your location.
So I used to screen, though, just so you know, because this map, I used to screen over here, close to the Berry Lane. And Bob Bullock, I don't know how many people came, but it was Bob Bullock.
It was all of
I think you
us.
were there, right?
Yeah, we were there.
So this was the area that they determined to be the spot.
Yeah.
And at the same time, I was told by Justin that the berm had to go along the property. They no longer wanted the berm. So when I removed the berm at the request of the selectmen, I believe, and Justin, that's when Bob came. While I was doing that, he came and cease and desisted me and gave me a stop work order. And I said, Bob, all I'm doing is taking this out because they don't want it. The town requested this. He said, well, I got to do my job. And okay, that's fine.
Never
So-
work before the ink is dry, my dude.
So that got my next stop work order.
So going up the map here, let's say the parking area for equipment and vehicles, what's parked there for equipment?
In the
and vehicles?
winter, my excavators will sit there because we don't do a lot of excavating in the winter. They just sit parked. And in the summer, there's not much up there now. There's a front end loader.
You plow or anything?
Snow plows, I believe.
Yeah,
You
there's
have
no snow plows.
Oh, there's none
Because
now.
the neighbors complained I scrapped them all because they made so much noise.
I guess my
They do
question, so typically there's a front end loader,
Yep.
and what else?
The pickup trucks and the 2 dump trucks will park up there.
And where are these pieces of equipment used?
On his site. It's
On his site,
property.
in the
No.
fields.
Yeah, but they're also used on your...
On my
your
jobs. I do
jobs.
both.
Yeah.
The neighbors, I remember them talking about it. How many truckloads of material comes in when you're doing a screening operation?
It depends. Right now, I have barely any loom up there at all because I'm trying to figure out if I'm only leasing for 1 year, then I don't want a big pile there that I have to move. So I did a job actually close by and I brought the loom there and I screened it. I've screened 2 days there this whole summer, or this whole spring and summer, 2 days.
And when you screened in the designated
In the
screening area?
designated area. The only thing on the other spot over the other side, there's been a guy that has horses bringing in horse manure, and he doesn't bring a lot, and like I said, we want to spread loom on that side. Actually, what I want to do is strip this and put this loom over there. But, yeah, that's the only thing that we're doing over there. We can't really, I'd stay away from there.
Now, with the new screening area, have we had any complaints from any of the neighbors or any of the neighbors on?
The only complaint that I heard about was I was dumping raw sewage up there, and I proved that through the Board of Health because that would bankrupt me. And this isn't the first time, I've made the Board of Health inspect at any given time. I don't want to know when you're coming. I want to know nothing. If I have to pay for the inspections, I'll pay for the inspections. And he actually submitted a letter to town council, I believe, or to the select board, stating he's never seen anything up there. I keep it as clean as a whistle up there.
So since you've moved the equipment, we've had no complaints from neighbors?
I don't know. I don't think they'll ever be happy.
Yeah.
Regardless of what happens with the lease or any extensions or any other litigation on use or ownership or occupancy of that property, your request is that you're comfortable with if we were to so vote that there could be a condition of that use continued for no more than 1 year, regardless of what happens with the lease or ownership or...
What if I bought it next year?
That's my question.
That's what I'm
just
asking.
going about what council...
That's what I'm asking.
And then you'd own it. I mean, that's the answer, but I can't tell you how that would impact it. If you bought it, you'd own it. But my question is, council said that the use would be for 1 year, no more than 1 year.
At this time, that's where it is.
Well, that's where we're sitting here today. I mean,
So I could be back here in a year to say, hey, listen, I got to go
so
through
I just
all
want to
this.
clarify that that's something that you wouldn't necessarily appeal if we got to that vote, and it had a 1 year condition on it. I'm just clarifying.
You have somebody asking a question in the audience?
No, we're asking Tim a question first.
Okay.
I mean, at that point, if I owned it in a year, I would be wanting to continue.
Or even if you leased it for more than a
Yes.
year, you
And what I'd
would
like-
come back, you'd feel comfortable coming back and asking for more time.
My plan, if I can come to an agreement on this, which, from what I understand, there's developers interested that want to do big things, I would put a tree farm on this portion. I want to grow all kinds of trees. That was always my thing. I wanted to grow trees. right now, this is all butternut squash from this line to over here somewhere. The other field, John isn't feeling good, so we just let it be grass.
I don't understand. You can't grow trees today. I don't understand.
I can't grow trees if I don't own it, because if I don't own it, I'll have thousands of dollars in the ground.
Okay.
It's okay doing a seasonal crop, but trees are not seasonal.
Right.
I understand that.
Wasn't there supposed to, there's a recent action in the eviction case.
There is an action brought by the Zertz family to evict.
Wasn't there
Tim.
something recently, I thought there was an event with the court that was happening
We've
between that
continued-
last meeting and this
It didn't
meeting?
happen.
We've continued the
Didn't
trial of
happen.
that matter to September 8th.
Okay.
Okay. Town council, do you have anything to add? Or you had a question.
Yeah, he had it.
Let us know who you are and then.
Thank you. My name is Bill Lenahan. I'm an attorney. I represent the trust that owns the property. I'm here basically to support Mr. Conowitz's one-year effort to finish out his business. He's been there for 20 years. Times change, and it looks as if the family that controls the property does not want to continue to use it as a farm. They're interested in selling it. If Mr. Conowitz is one of two best buyers, then it could be his. In the meantime, I'd like to see him get permission to run his operation for the limited period of time in accordance with whatever regulations the town imposes. I don't want the trust, excuse me, to look as if we are not honoring any applicable provision. We would be as interested in ensuring that he complies with your rules as your new building inspector will be when we come to that point. But we have reached an agreement. We continued the eviction because it appeared as if we have an agreement regarding his short-term one-year use of the property.
So along with his one-year use, since you have you have additional knowledge of the use of the property, is that screened area, the two screened areas and the parking area, is that primarily used for farming that property? Or
Farming the subject property.
The subject property.
Where this screening area, does that screening serve 115 parking area, or is this what's
I don't know how
screened
many
there?
acres are in blue there. You
Yeah.
said about a 17-acre site.
Or does what
you
gets
got a
screened there
house.
go off-site?
It's a lot of equipment.
13 acres.
It's 12, excuse me, it's 12.1 acres to be exact. This isn't 2 acres.
Okay.
It's just under. Where I was screening before was 2 acres just in that spot. I've cut my size way down with Bob Bullock.
Right. So what I'm asking counsel for the owner is if he has any knowledge, is that 2-acre use is laid out there, is that primarily for farming any portion of the remaining parcel?
Honestly, I'm not familiar with the historical usage, and so I don't know what the current usage bears to what has occurred in the past, so I can't comment on that.
So even currently, you wouldn't know?
I do not.
What's the question?
The question is, the area that's in purple,
This right
two
here.
screened areas in the vehicle area.
All right, so that's one area. I don't know what that is.
Okay, so that whole area there, right?
Yep.
Is what's done there to support, to primarily support the farming going on elsewhere on the same property? Is it primary for that?
This is all farming. This is all farming. And the piece where I was is all going to be all farming.
I understand
So this
But
was
the products of your screening, are they used primarily on-site or off-site?
both.
So there's two primaries?
Yep.
Okay.
Okay.
And the equipment's used primarily for two things?
Yes.
Is it used primarily on-site or off-site?
Percentage-wise.
Is it like on jobs more often
It's
than
hard.
not?
Yeah, they're on jobs more than they're there.
Okay.
Okay, that's the question, thank you.
Okay. I have a couple questions for our council. Do we have the ability to settle this by private agreement due to ongoing litigation instead of instead of this board making a different determination regarding the appeal of the building commissioner's decision? Because there's been ongoing negotiations.
Well, there's no settlement now.
Yeah.
This is an appeal hearing.
Yeah. Could there
This is
be a
not a litigation
settlement separate from us
conversation.
making a decision?
I'm sorry, I interrupted you.
Could there be instead of us making another decision on the appeal and instead of doing what's requested, is there an avenue to settle separate from that process?
Technically, there is an avenue.
Okay. I think the board
Wait, I'll
has
remind-
discomfort encumbering this property for this use in perpetuity versus a one-year situation. And so I think the strategy we'd be looking for is how to protect us from a ongoing use and being able to take this up again should the property be sold, perhaps to Mr. Conowitz. And I don't
think
want
that's
to lose our
outside the
ability to
board's-
support this, and I don't want it going on in perpetuity. I'll put it that way.
Well, I guess I'll put it two ways. As far as settlement goes, there's two cases
Yeah.
in court right now. The select board decides when to settle litigation. So this board cannot settle the litigation itself, whether tonight or
I
or some other
recognize that. I'm
exec-
just saying, separate from that, because we are being asked to redecide on the appeal and say, oh, you know what, last time we said we agreed with the building commissioner, but this time we're going to say, no, your appeal is fair, but we're going to, subject to the following conditions, we're going to let this continue to happen. What I'm trying to see is if we can avoid saying that we thought that the building commissioner was incorrect, because I don't, in the original finding for the cease and desist, because I think the board still believes that the building commissioner found correctly, which is why, on some level, the one-year factor is going to be very important to us as to not encumber this land in any way beyond a year.
Well, I think there's a separate issue with this
So how to get
one-year
there.
conversation, right?
Yeah.
So this is not like a permit that you can
Yeah.
condition. You
That's
either-
why I'm like, there's an appeal which we're
Well, no,
pretty.
we can always
Continue
but-
the
Yeah.
hearing if
We can kick the can on the appeal and just leave it basically open is the thing. And so my question, kind of closed as it were, because it's more or less closed. And so by settlement, we can get conditions, but by the appeal, by doing anything with the building commissioner, we're either in favor or against his action.
Right, so in the context of this hearing,
Yeah.
you can affirm building commissioner or overrule him. I don't think you can, within that context, condition
Right.
That we
uses
understand that. which
because,
is-
no, I know, but because it's either a violation or it's not.
Right.
And it doesn't make much sense that it's not a violation on the top of the property, but it is a violation on the other side of the
Agreed.
property, so.
So I don't think what is being asked of the board tonight is necessarily, because I think what is being asked of us is to, again, look at the appeal of the building commissioner's
Right.
determination, which
Thumbs up, thumbs down.
which is a yay or nay, which is why I'm asking you if there is another avenue via the settlement to get to a halfway
There is a
point.
technical avenue that could possibly work, but we've all, in good faith, have been trying very hard over the last, I don't know, 7 months or something.
I don't, that's not germane to me, though, so.
I guess my question then is,
Settlement is out of this board's control.
We understand that, that's the Board of Selectmen, but we're trying to get to a place where we can satisfy this gentleman who's looking for a year. You're fine. We can satisfy this board's concern that we both affirm that the building commissioner made the right decision in the first place, and secondarily, not encumber this property in perpetuity for this accessory use, because that is not something that we want. So strategically, I understand you don't want to hear this, but strategically, I'm asking you how we get there as a town, not
I don't know
we get
how
there
you
as a board.
I don't know how you affirm the building commissioner and allow the activity to continue. Because he said the activity has to
It's
stop.
a declination, I mean, technically, it would be a settlement between the town and the applicant to basically decline enforcement for a one-year period as they wrap up operation. You're allowed to do an enforcement schedule, or you're
Yeah,
allowed to put somebody on a schedule to come into compliance.
Right, but because it's either a violation or it's not.
I understand.
I know,
You got a little bit
but the next
pregnant kind
part
of
is that
situation.
this board cannot, I don't even know what you'd call it.
We can only
Condition
ask.
or order the future building inspector not to enforce the zoning bylaw because,
No, but we
You know,
could, but by proxy of the town itself and the Board of Selectmen, who the building commissioner serves at the pleasure of, should that board come to a settlement on this enforcement action.
that's up to the
wouldn't
board,
that
it's up to the select board. Trying.
I understand. Strategy is not about what is a yes or a no at the moment. It is about, can you get there? And so what I'm asking you strategically is just, if there's an avenue where we can request to the Board of Selectmen that, yes, we'd like to see this settled, we'd like the court, in exchange, we'll withdraw from court. I know that suit has no further action, but again, I know, just hang on with me for one moment. But if there's again, it's not saying that it's not a violation and you can continue doing it. It's saying it is a violation and you can wrap it up in a year.
That's why I was going with the continue.
Yeah.
Could I interject? Because
I just want to hear his answer first.
I'm sorry.
I don't mean to be dense, but I think my answer is the same. In the context of this hearing, there's either a violation or there's not. That's up to the board. I'm not giving my opinion on whether there's a violation or not, but I don't think there is a back door out of this to support the building commissioner's decision while simultaneously allowing the activity to continue.
But yet we're still here, so we've been supporting the building commissioner for a while here.
If I'm misunderstanding, I'm sorry.
You're not misunderstanding, because I'm asking you a question that exceeds this board's authority, because it's like the two-parter. Can we ask the Board of Selectmen if they'd consider doing something like that?
You certainly can, and the select board is aware of past settlement discussions that I cannot discuss in public.
So, I was going to ask, are we being faced with only the option if we want to continue this?
We can also continue it. We don't have to make a decision either.
Is he able to operate under these conditions that are here on the screen while this thing is continued?
He's currently subject to a cease and desist, so I suspect the clock is ticking on fines, isn't he?
Well, I think our position is there was previous enforcement, previous zoning board decisions that are on appeal at the Superior Court. I think it's the town's position that he's not supposed to be
doing this
at all.
Yeah.
Right.
So
I
then
think
that's our position in the litigation.
If I could just point something out to your question about saying that they not wanting to change your view of what the building commissioner did previously. This stop work order specifically talks about excavation and trucking activities. I'm not sure that's exactly what was in the previous decision of the.
I don't think we're disputing any element of how this site operates at this moment in time.
No, but the stop work order relates. This stop work order relates to excavation and trucking activities, and as I've stated, I don't think those Tim's activities on the property for ancillary to the agricultural use do not constitute trucking or excavating activities in my view. And I think that is, if I could be helpful, that's one way to thread the needle between the previous decision.
Well, we certainly know that is your view, but we don't necessarily agree with you that isn't occurring, particularly when the applicant gives us testimony about how the trucks come and go and the economic factors involved of why they come and go.
If I may, had we gone forward with the eviction a couple of weeks ago, one of the issues that the court was going to confront us with
Can
was...
we pause for a minute? Can you use microphone?
Oh, I'm sorry.
Could you start again? I'm sorry.
Okay. One of the issues that the court was going to ask us to address was, what is the reasonable period of time if I succeeded in evicting this tenant that he has to actually move out, keeping in mind that he's been there for 20 years?
I heard it was several pieces of equipment.
Those pieces of equipment haven't been there for 25 years.
The extent of the operation is actually literally several
Equipment
pieces
has
of
been there
equipment.
25 years, but not that particular equipment.
And so that doesn't,
I'm not, well, let me finish my thought, okay? What I'm suggesting is this. This board could consider allowing a reasonable period of time for him to vacate the property, not later than 1 year, and then you are not disregarding the building inspector. You're not saying no. You are giving this fellow an opportunity to comply with the order against him and move out in due course.
that's what we were talking about in terms of a settlement. Should the Board of Selectmen in their wisdom see that as a reasonable route to settle, to say that a year is enough time, or 90 days, 6 months, whatever it is.
And I have
action
a
than
very
ours, though.
compelling argument. He's a wonderful man. He gets paid very well for the job that he does, and he's got 2 separate pieces of litigation. I've got a separate piece of litigation involving Mr. Conowitz and the eviction proceeding. All of that would go away. The cost to the town is what I'm pointing out.
Yeah, we'd like it to settle. We're just trying to figure out how to settle and not encumber it forever, so that this is still happening 5 years from now and we're still listening to the same thing.
I'm not interested in that. We are in the process of negotiating a lease that has an absolute drop-dead date of 1 year. I've been asked to put into that lease an option to move out early if he can find another place to go to. So in the spirit of that, I think that I can enter into a lease while my prospective other buyer files for a permission to build a much bigger project that we all know is going to take 12 to 18 months to get through the permitting process. In the meantime, therefore, I don't want him on the property after a year.
But this is really a zoning, this is a use issue, whether, it's not a lease.
I would rather have houses than an industrial use masquerading as an agricultural
It's an appeal
use.
from the building department's decision, and that's what we're charged with. It's not whether or not, I know I brought up the question just to verify the 12-month, but that's not really the issue that we have in front of us.
That's something that could
You
be.
suggested a settlement path, but anything's possible, but I think our charge is very narrow.
I think we've heard all sides. I think we need to come up with a decision as a board this evening as to whether to enforce the enforcement that's on the table now by Bob Bullock or not, and find that way. I don't even know if, it's a yes or no answer. Is this
a violation?
Is this a violation or not a violation? That's what's before us. From everything that we've heard, we've seen, we've gone and visited, we've spent a lot of time with this, and I believe tonight is the night that we need to determine whether it is in violation or not in violation. And that's all our job as a board is. It would be nice if we could get all the pieces together and everything else, but us as a board, we're only a yes or no right now. Am I correct?
Or maybe later. We have a maybe later option.
We do have a maybe later option.
Or maybe later, but yeah, you're right.
I think it would be wise to keep it open and give it one more chance to settle between our next meeting and see if
I don't think the settlement is here.
No.
I think and I believe what I've kind of heard in the discussion tonight is that there's an agreement of a year.
Yes.
There's no settlement happening until a year from now, in reality.
Well, no, because if the town settles this entire action, the Board of Selectmen comes to an agreement with these gentlemen, all parties involved, and says, okay, this has occurred, you have 1 year to remedy it, that becomes their settlement agreement. We're not part of it. And so we can leave it open, leave them the option, should they choose to move in that direction and come to an agreement with these gentlemen, withdraw our litigation, perhaps you withdraw your eviction, And at that point, we have a binding agreement with this gentleman as a town that starts the 1-year clock on him ceasing his operations and curing the violation.
Is that a possibility? That's kind of a, in my opinion, that sounds like a far.
So I can't really talk about this in public,
Okay.
right? But I just think in general, there's a lot of ifs.
Right.
There is,
In
but
that,
we've got
and-
time to give.
I am not expecting to go back before the select board on this litigation matter anytime soon. So I wouldn't count.
What if they come to you with an agreement? Would you say
about-
pound sand or?
No.
How about we go to the
I'm not the one who says pound sand. I just pass
Yeah,
along.
well, I'm just saying, if they submit another agreement for consideration, I think that look, I know that you all have been arguing about this with the town. All of us have given hours of our evening for this matter. None of us have anything to do with it, quite frankly. And so I'm just saying, I think we're trying to all facilitate the same end. I think, at least I'm pretty clear about how I feel about everything, so there's no question here about what I think. But if there's room to leave it open to give the town an avenue,
It's late, so maybe not a clear thought, but we have an option that we could continue it, but if we were to do, before we were to do that, we could do a straw poll if you wanted to, and that may motivate people one way or the other. I don't know. It's not a binding vote.
what would happen if we vote tonight versus if we wait and see if they submit a settlement offer. Would you entertain submitting a settlement offer to the town? Would you put the hours in?
I, like Mr. O'Reilly, am constrained by what I can say in public on this topic. I will tell you that there's a reason why this hearing's been continued a number of times.
Okay, would you find it beneficial for us to opine this evening, or would you rather wait and see if you can get a different result if we do a straw poll and you don't like it? So we're giving you the option, I guess, to try to settle it one more time or to basically take your licks tonight.
Well, I'm all for leaving open the option to settle it, and however the board elects to do that. And I'll tell you, would you want to? You're suggesting that we have.
I'm gonna ask your client real quick too. Are you in any level entertaining the idea of this, or are you, as soon as we leave, going to say, don't you dare, submit a settlement offer that says that, because we don't have to waste time on this?
What do you mean by
You don't have to.
You don't have
tell her what you're
to.
gonna
Yeah,
tell
you
your
definitely
attorney.
don't have to. But like, if they basically what's on the table is a year.
There's nothing on the table.
Well, there's
right
nothing
now.
on the table. There's either we
There's
wait,
nothing on
see
the-
if you can put together another offer.
a yay or nay.
There's
We've been working on the offer for months. That's why this keeps getting postponed.
Yeah.
And there's a certain guy that has caused me all this problem that's on your planning board that's using town council for his own gain. And a lot of people in the town of Norfolk are asking me how much of our tax money's going to this. So there's going to be FOIA requests coming.
Well, I don't know. I pay like $13,000 in taxes and have no kids in school, so that we can fund it.
So as for me, with how much I've spent already.
Oh, I don't care how much you spend. I just want to know, like,
I'm going to keep fighting this.
okay, I'm just like, I'm trying to take your temperature gauge on settling.
If I can settle it,
Yeah.
Please, let's stop.
if I can settle it,
Let's just
100% I will.
Okay. So,
So tonight, we have an option of, there's 3 options on our table: yes, no, or continuance. And that's what we've got on the table tonight. That's what we're going to vote on. We're not going to straw vote it. We're going to vote it.
okay.
And that's all we're going to do. I am not in the market to continue going on unless we continue.
I'm kind of like,
I want to know that it'll be productive if we
Yeah.
continue, because we can just end it,
Right.
is kind of my thought.
That's what I'm thinking,
That's
too.
what I'm trying to get from the.
That's what I'm thinking.
Yeah, if it'll be.
I don't see a continuance in a help, as a help.
right. So,
But I could be wrong, and I don't know that, but We've heard all sides as far as we can tell. We've got a decision on the floor to either appeal the building commissioner's letter ceases and desist, or we stick with the letter of cease and desist.
Do we close this hearing and then deliberate?
I think we do.
Right, so we want to close the hearing?
Or
and
do we
then-
keep it open?
Well, you close it,
and
then it's going
continue?
to come to one.
Yeah. Oh, you don't think we'll ever, you don't think we'll deliberate it?
No, I don't know.
Deliberate,
Well,
yeah.
I guess we
But no
just-
testimony. But we might take more testimony from town council.
Oh,
on an
not
update.
testimony.
Right,
Not
right,
testimony, but-
right. But I would have to, we have to close the hearing first before we make a decision, correct?
Yes.
Yes, right, so.
And are you suggesting that deliberation take place at a future date or tonight?
Well, I guess we have an option of
Yeah,
either
that-
deliberating tonight or deliberating next time. It's up to us. Do we have that option?
We do.
Got 90 days.
We have 90 days.
You have the
for
option.
closing.
If you close the hearing to
Right.
deliberate next time,
Right.
you're not going to,
Closed, we're
So then we're
closed.
back to a continuance.
If we're back to a continuance, if we're
At some
looking
point- at some
for
Right.
some more information, or if we're
Right.
willing to stand here.
Wait for an event.
I think, I mean,
there is no event.
I don't think there's
Yeah,
any event.
there's no event.
I'll make a
It's their
motion that we close
goodwill.
the hearing. And the reason I'm making that motion is no one's suggested to me I'm going to hear anything new between now and the end of the world. So,
All right, you make the motion to close the hearing.
Close the
I'll
hearing.
second that.
Do I hear motion favor? Aye or nay?
Aye, I'm in favor.
Aye,
Aye.
to close the hearing.
We're going to close the hearing. Hearing's closed. Thank you. We'll let you know when we have a decision.
So when will the deliberation, is that going to take place this evening, or is that going to take place?
It could.
Yeah, okay.
It could take place next week, next month.
We have, what's the window
Well,
now for decision?
We have 90 days, correct?
Yes, but if you're going to vote next time, you have to continue the hearing to next time.
Right, that's where I was getting.
Or if you're going to deliberate tonight,
Then we'll
you got to
deliberate and
deliberate
vote
tonight,
tonight.
and then you got to vote tonight.
Yep. Then we'll deliberate and vote tonight. We've already closed the hearing.
Okay.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you very much.
You want to do a straw poll for deliberations?
Well, first, do we want to handle the next appointment
I
first?
think
Oh,
we
do
want
we
to
have
handle
another
the next
appointment?
appointment.
Oh, my gosh, we still have things to do. Sorry, guys.
Mr. Kelly, are you here and present?
Yes.
194 Main Street, 40B permit extension.
Yep, this is Owen Kelly coming for 194. Sorry, I thought this.
Okay, yep, you can do that.
Yep, thank you. Owen Kelly coming for 194 Main Street. We are asking for another extension request because we're still currently discussing with the town potential project revisions and things like that. We are more than happy to move forward with the project that is, but I think there are still generative ideas going on, and so we've continued along that front.
Eileen, do you know about those discussions or anything? Do you know anything about them?
So more discussing, we've gotten proposals from, suggestions from members of the town that have seemed in line with the town's master plan, not necessarily speaking with members of the board or anything like that.
Would this be like a change in what the permit already is?
If that came to, we would come to the board and do a modification request.
Okay.
Along those lines, if one of those.
They're asking for a one-year extension.
Collaboration's a great reason to offer an extension.
What do you think, Tim?
yeah, my question is, when does the permit expire?
It's a great question. They had the general extension order that went out
This one
from the
pulled?
state,
Yeah.
the 2-year extension. So I actually don't think, I think right now it expires 2 years from now, but we also wanted to have the discussion in case figured we'd come here and discuss it before. Without that extension, it expired now, or like this next month.
You're not looking for an extension beyond those 2 years, you're looking.
No,
for just not-
right,
it's that- the
kind of just
interpretation of that.
confirming that this is.
I got
It's okay to continue making progress
Right,
as you're
right,
doing,
right.
yeah. Fair.
So you don't actually have to, I don't think you have to grant the extension so long as we're all in agreement that.
Yeah.
Yeah, but we have to, this is basically, we're considering it as an insubstantial change by extending it, right?
Well, there's no change.
There is no change. It's, we're
At
not
this moment.
changing
You have to
anything,
grant this request.
Yeah.
we're only modifying the timeframe.
Right.
So I guess it's an
Right, so I think I would make the motion that we were going to extend the timeframe from to June 18, 2022, 2026, I'm sorry.
2026.
It's a minor modification.
As an insubstantial change
Yep.
to the comprehensive permit. Is that clean
I'll
enough?
second that.
All right, thank you.
All in favor, say aye.
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 Thank you.
So you just cut a year off your plan.
I think.
That's right.
Good night.
Touche. Good night.
very much. Appreciate
Thank
it.
you. All right. Now-
Updates.
I don't think there's any updates. I think we could do deliberates now. We have one deliberation for tonight. And that's the 115. Do we believe the building commissioner was correct in his cease and desist of the excavating and trucking operation at 115 Park Street? That's the question on the table, because that's what the letter was.
Have we heard anything different?
That there isn't trucking and excavating going on?
Right.
I think it's more of instead of excavating, I think it's a screening operation.
Excavating
And
on other
trucking.
sites.
I think trucking's still there. And I think you have trucks coming in and trucks going out, loaded, so that's a trucking operation. Excavators are being used, or front-end loaders are being used in the screening process, so that's there too. So I would venture to say that his decision, or his letter, was correct. One thing that I would probably want in stating is that if it was truly agricultural, the agricultural side would be a greater amount of time, energy, and effort than on the commercial side. And it does not appear to be that from what I see. And speaking as a farmer, I mean, I truly, people doing stuff or bringing stuff for us to take care of and do and either house or whatever helps to offset our costs, but we're always mindful as to whether that's what we're there for. Are we there for agricultural purposes? Are we there for commercial purposes? And I've always thought that we're there for agricultural purposes. And realistically, there's still agricultural going on the property. There's still squash being planted. There's still other stuff being planted. But is this process that is asked to cease and desist, is that helping that process more than 50% of its time being there? And I don't see that. I planted gardens for most of my life before I got cattle. And, you plant them once in the beginning, and then you plant, you till at the end of the season, and you're pretty much done. And you're not screening and doing all that kind of stuff for years. And I mean, I've been a part of 1,200 acres at a point, and I've never seen this much of an activity just for one 12-acre parcel on anything. That does that mean that it didn't benefit the farm? I believe it benefited the farm in a big way, because I believe there was work that helped the farm. I also believe that there were taxes paid to help the farm. There were all kinds of different ways that helped the farm. But is it really a farm activity or is it a commercial activity is the question. And I would say more than 50% of the time of the trucks going in and out and the screening and everything else is more off-site than farm, from everything I saw and from what I've even had discussed tonight. So in the hearing, I would venture to say that Mr. Bullock's decision was right, that it should cease and desist.
Yeah.
And
if you go back to the time when when Bob had issued his decision, or his,
yeah.
If you go back to the time, I know maybe it's been a big scale back of what's going on right now, but if you go back, that's been our dilemma all this time, is that we were kind of like, we can't tell Bob that he was incorrect, though. And
right.
So I kind of support what you're saying. At the same time, like I say, even though it's scaled back, it still goes back to the initial reason we're here.
Right.
And that I have to agree that it's been very hard to say that Bob was wrong.
And I think the cease and desist, I don't have the document right in front of me, but I could be corrected or reminded, but the order was specific. I think, or it noted that not cease and desist any farm work or things associated with the farm work. It's the other things.
Right.
So I think it's a narrow view, and
so in reality, if I hear what Bob wrote in his letter and what I know of as being farming, if there's a portion of the farm that needed to have piles that were there and everything else that are there that need to be screened so that they can then flatten them and make them useful farm again, I have no problem with that being done. If it's trucking where you're bringing in trucks loaded with loam and you're dumping them in a pile and then screening them to remove from the site again to go somewhere else, that's a commercial operation. That's not farm related. And I believe that's what was to cease and desist. The farming side of it isn't needing to stop. So if there's stuff still there that needs to be cleaned up, clean it up. Get it back to farm lands and do all that. We're all for that. We believe in it. But the stop order says you're ordered to cease and desist all excavation and trucking activities. I believe that excavation and trucking activities were related to the screening process that was going on. And I believe it's still going on. You made mention of that even today. So I think it needs to stop. And if it's associated with the farm only, as you said, the corner over by the section that's kind of still rough and is not in farmland, I don't have an issue with that getting back into farmland. So if you have to screen stuff to do that and make it right, we have no problem doing that. But if you're bringing material from off-site, on-site to screen and then bring back off-site, we have an issue with that. Do we have an issue with you parking equipment up there? I don't believe so, because I believe some of that time, and I have equipment that's parked at my house sometimes that's from others. We use it on the farm, they park it there, they leave, and vice versa. It's a constant, you scratch my back, I scratch yours kind of thing. I don't see that as the issue. It's the issue of bringing stuff in from off-site to then remove again to benefit yourself in a dollars and cents manner. That's a commercial operation. I don't believe that's what should be going on. I do wood. Sometimes guys bring me wood from job sites, but it's my wood now. It's not theirs. I then sell it to clients and everything else after I process it, or I burn it for myself.
Processing forest products is also a recognized agricultural use as opposed to an accessory
No, correct.
use.
And it's completely agricultural. Would somebody argue that that's commercial? Shoot, I think if I brought in big equipment and started processing, hundreds of cords, yeah, probably somebody could have an argument and say that that's a commercial process, especially if it wasn't me. If I allowed somebody to come in and do that on my site, I would think that would be a commercial progress. And I would never do that, just because that's not part of my farm. So I think they've allowed you to do stuff there for the last 25 years that wasn't necessarily questioned by the town or neighbors or them as being commercial versus farm, because there was a benefit being had on both sides. And I can see that. I'm not arguing that. I think it was beneficial to both parties, you and him. But is there excavation trucking activities going on? From your own mouth, you've said yes. And I would say, don't do it anymore. That's what the stop work order is for. And that's where I'm,
If we go back to the timeline of all this, we upheld this before, right?
Yes.
Yes.
On appeal.
That was on appeal.
Right.
And that's what we're here for.
No, this is a
new event with a new cease and desist, just a narrow, the narrow use of trucking and excavation.
But going to what David just said, we're going back to the same reason. We're still gonna,
Yeah,
we're still filling in.
it's still, at the end of the day, it's still looking at what is the primary versus accessory use of the structure, and I think what's being determined here is that the primary use of the property is in fact this excavation business. The farm is accessory, though it buys a lot of rights, and the residential use is the lowest in.
Is this,
yes.
in the end, do you need a majority vote here?
disagree with them.
5 out of 4.
4 out of 5.
4, sorry.
It's late.
Head spinning.
Long day.
To overturn Bob's order,
Right.
you need 4 out of 5 votes.
Okay,
So anything less than that.
okay. How many people will be
Affirms it.
voting on this tonight? We got 1, 2,
Well,
3,
Oh, you don't need me, so it's just you guys.
There's 5, we got a full
5.
board.
Okay, all right. Yeah, I don't see us overturning Bob's order.
I don't think we've heard anything different from what we had the last time.
I think, why doesn't somebody make a motion to
Support the determination of the building commissioner.
determination of,
Deny the appeal.
That's what we are, we're denying the
Yeah.
appeal.
I would do it, I would have the motion to sorry.
Affirm the cease and
No,
desist.
because this is the thing.
uphold the
Deny the appeal.
Deny the appeal,
Deny
uphold
the
the cease and
appeal.
Or appeal
desist.
to grant denied. I mean, you can do.
Appeal the appeal. We would affirmatively.
Vote to.
We
vote-
deny the appeal of the building commissioner and affirm his issuance of the cease and desist, right? That's the order.
We're back,
Vice versa.
this was an appeal of the building commissioner's cease and desist, right?
Yeah.
We're just, we're denying the.
We're either approving or denying the appeal.
That's the options.
All right,
So if you approve the
I'm gonna-
appeal,
yeah,
it means that you disagree with the building commissioner. If
Got you.
you deny the appeal, it means you agree with the building commissioner.
All right, and we need at least,
You need 4 out of 5
to turn.
to appeal the building commissioner and just a normal
Right.
majority to deny.
All right, so,
I think.
all right, I'll make the motion that we deny the appeal of the building commissioner's cease and desist for 115 Park Street.
I'll second that motion.
any discussion before we vote?
No.
Okay, all in favor, say aye.
You have to use names here, or?
No, we're not on,
Aye. Aye.
So your aye says.
That we're denying the...
You're denying
Yes.
the
Yeah.
appeal.
Right.
Yeah, that's the motion, to deny the appeal.
Oh.
All in favor?
Aye.
Aye.
All against? Any against?
Anybody against?
Nobody.
Noes? No nays? Okay. All right, the appeal is denied, gentlemen.
Thank you.
We have minutes from May 21st, if anybody's
Yeah,
pumped
there's one-
about another wonderful set
There's
of
one-
Elaine minutes.
Right, just one edit, though. We have to correct the, I think...
There's a minor correction there.
Right, so we can approve the minutes with the corrections as edited.
Absolutely.
You're welcome. Have a good night. Good luck.
Thank you, gentlemen.
Good luck with it.
All right, I'll make a motion that we accept the minutes from May 21st, 2025, with the edits as written. Give you a second.
Thank you.
Thank you, Tony.
Give me a second.
I don't know if that helped you or did not help or anything else, but.
It's fine. It's good.
We're volunteers, we can do no wrong.
We had to come up with something. I mean, it just keeps going around and around.
It's the same thing. It's fine.
Yeah.
All right.
All right, thank you.
Good night, thank you.
Appreciate it, Tony.
All right, I'll
So I
repeat.
seconded the motion.
All right, okay, you got it? Okay.
As amended.
All right, so we have everyone, all right, so everyone in favor?
All in favor?
Yes, aye.
Aye.
Beauty.
Tim, you second that, right?
I did. Yes, I did.
All right. We've got
Okay.
any old business or unanticipated business or correspondence? or
Oh, I have
anything?
a quick question. When do we have our next town meeting? Are we having a fall?
Sometime this fall, though.
Sometime this fall? I was thinking that we might want to do maybe do a little tweak to our camper regulation, along with the special permits for nonconformities, and put some limits
Right.
on that. I know I drafted one of those, but I haven't looked at the camper language. But if you guys want to do a little bylaw work, I thought maybe we could, put some language forward for the planning board to quarterback, because we're lazy quarterbacks and we like it when they do the zoning. And, because then it just stays with them in the zoning hearing and all of that. But if you guys are interested, these seem like things that keep percolating that we could probably take a quick whack at. Not for maybe,
I am not volunteering for that because I have to do the whole selecting of a.
Right, you're on that.
of the engineer.
Yeah.
I am willing to write both sentences.
Very good.
Perfect.
I am willing to do that and put it forward to you guys to consider.
We normally, I would have...
Camper use, is that what you're saying?
Yeah, for the camper use, and then when
Vague still, yeah.
and then when it's on the agenda, we can have like a discussion about what the tweaks would actually look like. But these two things keep coming
They
back,
do
and
come
it
up.
seems like something that it would be easier just to
Can we
provide
put that
it.
on for next month?
Yeah, because I'd
Would
like to
you be
have
all
Rich
right
here
with
to
that?
discuss it too, right?
Yeah,
right,
yeah,
with
yeah.
Rich.
Well, it's on, I'm like, we can't, I was just going to see if anybody was interested before I suggest that maybe we ask to put it on the agenda.
We keep the agenda for new old business, so we always have room to discuss it before the meeting closes.
But if I was going to write like two sentences, I thought we'd put it on the agenda. And
Yeah,
if
have
anybody
it-
had opinions.
I think that would be a good idea
Yep.
for the July meeting.
Could we call it bylaw cleanup, Elaine? And just discussion of potential articles, and that gives us a coverage for,
Yep.
Does
sentences.
any wording in the bylaws have to go in front of a town meeting or anything
yeah.
like that?
It's a 2/3 majority vote for any.
Yeah, so all
local
we're
power.
doing would be making a suggestion for.
Yeah, so we
Yep.
can make it less ambiguous.
It is
Yep.
ambiguous.
So-
It's too ambiguous now, I think.
So what we want to do, what I imagine, well, I don't know, we
Well,
can't
you-
discuss it, but I think the general tenor of the board has been more flexibility on the camper issue and some, limitations on the special permits for nonconformity. So I was going to just put forward some suggestions that we could
Sounds
talk
like a
about.
plan. That's a good idea.
But when I write, it's like laser surgery where we're only doing a sentence because we don't need more than a sentence to make this clearer.
Would we expand upon the provision somebody could be in a camper?
I would imagine that we might allow some temporary structure conditions.
Instead of just
Instead of what we're doing on an ad hoc basis, that we'd probably provide some limitation
And then when you
for
draft that
construction,
sentence, we can talk about it in a
renovation.
lot of
Yeah.
detail.
Yeah, but yeah, exactly. We can't talk in detail on it, but that was just a thought. I thought I somewhat understood how everyone felt, and that maybe
Sounds like
a
a
sentence
plan.
could be brought forward to discuss.
Right.
But
So you're gonna bring, provide proposed edits to what's already in the bylaws, right?
Yeah. I'm just gonna submit one page and then send
Sure.
it to
The way it's written in
Rich,
the
and then
bylaw
you guys
now-
can see it,
Yep.
and then we discuss it. But that way, there's a little. That way we can just make sure it gets done.
So that'll be on next month's
The way
agenda.
that it's been written in the bylaw now, the house would be inhabitable and under some sort of,
You need a fire in order to live in a
Yeah.
camper, and I don't think we want to.
Fire, pestilence, or act of God.
Yeah.
Has to take the house out in order to
Yeah.
do it.
So
So,
we may want to make some tweaks.
yes.
and
discuss.
also on those tweaks, you might want to define what a mobile home is.
You noticed that the definition was a problem too. I also had noticed that we had some debate over that.
Yes.
So I thought that
That might be a definition.
this one is not hard. This one doesn't take a lot of work, which is why I'm volunteering to do
All right,
it.
good. Appreciate that.
It took
Do
more
I-
than-
oh, we have a couple
First off, we have to
things.
sign this, the modification.
Oh, yep.
This one?
All right, so I
I
need
have
a,
things to sign.
oh, yeah. So we have to sign also, now the decision.
Minutes.
The minutes.
Right.
That's him.
That's me. The fact that we denied the appeal, that's got to be written up, right?
Yes.
Okay, so it's not written up yet. All right, so we have to sign this tonight, who's ever signed the modification.
Right.
So I need a blue pen.
Oh, should we
And I
close the meeting?
Yes.
Yeah, now we can close the meeting. I just want to make sure we got it.
Can I have a motion to
Yeah.
close?
Yeah, so make a motion that we close the meeting, ZBA meeting for Wednesday, July 18th, 2025 at 8:55 PM.
Second. All in favor, say aye.
Aye. Just
So
in
moved.
time for the fireworks.
There you go. Thank you very much.